Following the launch of the first edition back in 2011, the fourth edition of the Environmental Law and Policy in Namibia is set to be launched. Now, the book comes as a result of much attention attracted by the first three editions. The Hans Zeidel Foundation Namibia, together with the Ministry of Environment, Forestry and Tourism, as well as the editor of all four editions, Professor Oliver Ruppel, from the Development and Rule of Law program at the Faculty of Law at the University of Stellenbosch, are spearheading the launch of the latest edition. To speak more about this latest edition, we're joined this morning by the man himself, that is Professor Oliver Ruppel, as well as Mr. Clemens van Dore, resident representative from the Hans Zeidel Foundation, Namibia. Good morning, gentlemen, and welcome to Good Morning, Namibia.
Good morning. Thank you for having us.
How are you doing on this gift of a Tuesday? You doing well, Prof?
Oh, well, perfect, yeah. Happy to be here in the land of the brave.
Awesome, yeah. Please walk us through the first three editions before we get to the fourth edition.
Well, we had the first edition out in 2011, always in cooperation with the Hans Zeidel Foundation here in Namibia, so that is a long-standing partnership. And it was a success. It addressed an issue that has become more and more important in the past years. The environment is something that we rely upon. We investigate issues of development, different sectors like water, forestry, fisheries, the oceans, the desert. Namibia is one of the driest countries in the world, most vulnerable to the aspects of climate change and the impacts of climate change, and therefore the law came in as a very necessary tool. And in the second and third edition, this has grown. The book became thicker and thicker, and it has contributed to legislative developments, case law emerging, and also more expertise in the country.
Would you say those are the primary differences between the fourth edition and the previous editions? The incorporation of case law as that developed, but also as far as reflecting the developments relating to climate change?
Well, the chapters have become more critical, more detailed, and the experts, we have almost 20 authors in the book, most of them being from Namibia, have contributed largely also with their experience and their backgrounds from the different sectors, from the legal fraternity. We have a judge who is contributing to the book, and we investigate the law from a national, regional, that is SADC, and the African Union and international law perspective.
Very well. Now, Sir, Prof. Ruppel has already touched on the background of the book and on the fourth edition as well as the previous editions. Please remind us about the aims and objectives of the book.
Well, the book is obviously there for practitioners, for the academia, for students to dive into the aspect of environmental law and policy making, to understand the crux of the matter better, to understand the different aspects and what to look out for, but also to give a look into the future. For instance, I was happy to contribute to a chapter on forestry, and we were talking about also in that chapter about what should be done in order to make the Namibia's Forestry Act fit for purpose. So it also points into the future to make it fit for purpose and prepare both the public sector, government, as well as the private sector on how to be ready to manage the natural resources better and more sustainably.
So how will the book serve as a tool to make this forestry sector fit for purpose?
Well, we put in, for instance, one big example is and I know the department, the Ministry of Environment, Forestry and Tourism actually has been looking at revising the Forestry Act, is that the current act is lacking a definition of what a forest is actually, and many other definitions. And now actually we know that the draft act as it is being prepared in the ministry has that, and what we already pointing this out in the book also on what should be there, what should be done in order to make it fit for purpose.
Very well. Prof, from your understanding, how will the legal fraternity be able to practically make use of this guiding tool?
Environmental law is a relatively new field of the law that is strongly emerging, also in the sense that it is less reactive than other fields of the law. In fact, environmental law is a field that is becoming more and more proactive in the way that it influences planning processes, that we attract investment, that we act sustainably, in a sense that we don't only measure the damage once it has occurred, but also we anticipate it and try to prevent it as far as possible. In that sense, this book is not only of guidance for legal practitioners, state prosecutors. I think the judiciary is very aware of the fact that this is an emerging field. More and more cases are becoming pending. And in fact, the first edition of this book was a response to a judges training that we have conducted here in Namibia for the Namibian judiciary in 2007 in cooperation with the United Nations Environment Programme, where the awareness was already there that this is becoming a very important field of the law.
And because it's an emerging field, one would accept that it is also very dynamic. How important is it for the law to be responsive and agile to these developments?
It's absolutely crucial. If you take, for instance, climate change, it is something that perhaps 10, 20 years ago, a lawyer did not deal with this subject matter. But today, this is a critical issue that permeates all sectors of our society, of our economy, of our of politics, and therefore the law needs to be adjusted to the changing environment, the changing living conditions, and the necessities that we bear as a human nature in order to survive and in order to make that planet fit for survival.
Fit for purpose. Now, Sir, Prof. Rupel has already shared with us that a judge contributed to the book. You've contributed to the chapter as well. Talk to us about the other contributing authors.
Well, as Professor Rupel already mentioned, almost 20 authors contributed to the book. Many of them are from, or most of them are from Namibia. I can just mention a few. Shirley Betune is one of them. Iliamani Laltaika is one of them. Isaac Mapuaure, Jonathan Kambwi. Some of them are actually lecturers here at the universities at UNAM and NUST. Others are actually, one is a judge of the High Court in Tanzania, for instance. So it's also people from the region who've contributed, who understand the context of the region and the nuances and what to look out for. And obviously they are experts in their field. It's a wide variety of different authors. We also have a mechanical or nuclear engineer as one of the authors, Detlof and Ertzen.
Why is that significant?
Well, one of the topics is energy, energy and climate, energy and the environment obviously is a key aspect. We're all talking about hydrogen nowadays, so it's a big topic. But there's more, obviously, than just hydrogen. And Detlof is an expert in his field and has a rich amount of experience. So he was important for us to contribute to that book. And for the editors, Dr. Rupel Schlichting and Professor Rupel.
Thank you. Now, Prof, to measure and gauge the true success of the work, one has to look at its impact. Please talk to us about the impact of the first 3 editions.
I think all of what this book aims to be is impactful in the sense that it wants to raise awareness. So this book is something that is used in other countries, even in Southern Africa, for educational purposes at universities, not only in law faculties, but it is a interdisciplinary piece. So it can be useful for an engineer, for someone in development, for someone in the banking sector, for someone in the industry overall. But on top of that, of course, it is a useful tool for legal practitioners to become familiar with the field of the law that is relatively complicated because of its complexity, because it touches on all aspects of our life. Our environment is everything. And therefore, we needed so many chapters that deal with so different cross-cutting issues. There's a chapter on human rights and the environment. There's a chapter on trade and the environment, on energy, on mining law, on biodiversity protection. And you can see, if you look at all the chapters in context, that is basically the entire economy with legal implications attached, and that's why I think it is most practical in nature, and not only for lawyers, but especially for lawyers.
Yes. Now, because it's not a statute, its binding nature might be limited, although it could serve as a persuasive tool in a court of law. Help us understand the difference between that.
I think that is a bit of a traditional perception, where environmental law was seen as an element of the law that is more aspirational in nature. We have to move away from that. We are reaching the limits of our boundary capacities, and therefore we need to consider the bindingness of our obligations towards international law commitments that Namibia has signed and ratified, and these need to be translated into the domestic level. In fact, Namibia is a very special case with Article 144 of the Namibian Constitution that in fact gives meaning to international law ab initio, they say, that is with initial effect. So the moment Namibia signs and ratifies an international treaty becomes very relevant for the domestic implications.
It need not be domesticated additionally, unless, of course, it's in conflict with the Constitution.
Absolutely.
Yeah. So you mentioned green hydrogen, and we can't talk about green hydrogen in isolation. There have been other developments. We have discovered oil recently in Namibia. To what extent can this book be used as a tool to also deal with those emerging realities?
Well, it contributes also to the energy sector. It dissects some of the challenges around that, always from an environmental law and policy perspective. It can help to steer decision makers, both public and private sector decision makers, on to take the right decision. Also in line with the Constitution. Article 95, sub-article L, also of the Constitution, refers to the sustainable use of natural resources, which is actually quite unique in the world, and I think quite cutting edge in terms of how a constitution can look like, that the natural resources can and should be used for the benefit of today's and future generations.
And that's a very express provision in the supreme law of the land.
Yeah.
Talk to us about the launch.
Yeah, the launch will be taking place tomorrow at NSFAF. It's at 10 o'clock it will start. We will have some introductory remarks by Professor Ruppel and myself. We will have a keynote speech by the Honourable Minister, Bambeshi Feta, who is also the guardian of the book, so to say, and followed by a panel discussion on what the value of the book is for Namibia, for practitioners in the different fields.
We said earlier, Prof, that this is a developing and emerging situation in the field. Which are the existing lacunas in the law that you have identified that we still need to close in terms of gaps?
That is, of course, a difficult question. If I hold a book in hand of 600 pages, if you want to have the gaps in a nutshell, it is difficult. But Dr. von Droderer already mentioned hydrogen, for instance. This is something that has high potential for Namibia, but we also have to be careful because it is a new development and there are gaps in our law, in the legal provisions, and also perhaps even statutes that may be missing in order to engage into a new development such as hydrogen that has risks attached and that has on the other hand also great interest for investors. But Namibia also has to protect its pristine environment, its deserts, its conservancies, its people, and Namibia is first and foremost one of the water scarcest countries in the world. And I think that is something we should not neglect. And therefore, we need to be very careful in all the developments that we attract and also assess whether it would not be sensible to create a legal basis that creates greater protection for the people also that will be working with this or will be in one way or another affected by such investments.
Now, in order to create that protection, in order to pursue that protection, there must be measures in place, legislative measures in place, to deal with those who do not honor that objective. But a punitive approach, as we know, isn't always the answer.
No, the law, especially environmental law, has two approaches. And in simple words, they can be sticks and they can be carrots. And in terms of sticks, you've mentioned the punitive approach. It is not always helpful. But carrots, these are incentives, incentive structures for people to adhere to the law, for investors to adhere to certain practices, labor rights, whatever. And therefore, incentives are very important.
Indeed.
A practical example could be, for instance, by not cutting a tree and leaving it there, the community being paid to protect the tree. That is an incentive. It might be tempting to cut the tree because you might have short-term gain, but by protecting it, by ensuring that the carbon is being stored as a tree and only used when it's ready to be used, that might be, for instance, a carrot to work with.
An additional carrot could be to encourage Namibians to plant
More
trees.
Course,
yeah. For those interested in the book, where can they obtain it?
They can get it from the Untitled Foundation's office at the House of Democracy. And obviously tomorrow at the launch we'll have a few copies ready for all visitors and participants of the event as well.
While you have the floor, any final remarks, please?
I would also point out that in Namibia, especially the local people have knowledge about environmental law. We've made an assessment many years ago about customary law and the environment. And I think we can learn a lot of the understanding of the traditions and the implications to protect the environment from the people. And the customary law is also something that is well covered in this book.
Thank you very much for your time and thank you for sharing your expertise this morning.
Thank you very much for having us.
Thank you.
There you have it. These gentlemen were talking all things environmental law and policy in Namibia.